For all the Jural Assemblies 48 Banking Corrections. April 19, 2019 by Anna von Reitz. There are two kinds of banking institutions available, federal and state. These institutions operate under different kinds of charters. As American state nationals and American state citizens, we should be using and supporting state-chartered banks and credit unions. Why? Because of the legal presumptions involved and the relative safety provided to depositors by state-chartered banks and credit unions. We long ago advised that non-federal employees and their dependents should shift their small business and private trust and trade name accounts to state-chartered banks and credit unions. We also suggest that people who have accounts in federal banks and credit unions provide the bank CEOs with a registered letter, return receipt requested, specifically instructing that all funds being deposited in and transferred out of such accounts held in our names be denominated as lawful funds. This prevents them from getting grabby in the case of a bank holiday or bail-in or similar fiasco. Federal banks don't actually have sufficient United States notes to trade in them. USNs are a foreign currency, but they are required to denominate the digits held in their accounts as United States notes, if and when depositors require this. Many people have had trouble locating the state-chartered banks and credit unions in their state. In Alaska, this information is available from the State of Alaska Division of Banking and Securities. The state banking commissioner in all states should have that information or be able to direct you to the proper office. A search by one of our more diligent researchers shows that there are only 4 state-chartered banks left in Alaska, only one of which is truly accessible and statewide in scope. There is only one state-chartered credit union, Credit Union 1. Thankfully, Credit Union 1 has state-chartered organizations in every state of the union. Each state assembly needs to research this topic for their state and their members, and make the information available to them. State-chartered banks and credit unions are in state depositories by definition, and as such, are not as likely to be affected by any international banking collapse resulting in the loss of depositors' assets. To bring this home to Americans, the state-chartered banks and credit unions are George Bailey, and the federal chartered banks and credit unions are Mr. Potter. It has been this way since the days when the movie, It's a Wonderful Life, was made, and it continues to be true today. The trouble with banking began in 1913 with the passage of the Federal Reserve Act, which imposed conditions that can only be described as contractual lunacy, leaving only Section 16 of the Act as remedy for it. From that time on, federally chartered banks were obligated to function under this patently criminal scheme. Section 16 of the Federal Reserve Act was codified as Title 12, Section 411, 12 U.S.C. 411, which spells out the remedy via proper endorsement of all banking instruments. Is it a check? It's a banking instrument. Is it a signature card? It's a banking instrument. Is it a court case? It's a banking instrument. Is it a savings account? It's a banking instrument. Is it a safety deposit agreement? It's a banking instrument. Is it a mortgage application? It's a banking instrument. Is it a mortgage closing document? It's a banking instrument. All these and more are being bonded, subject to bailment, and unless you specify otherwise using your signature correctly, you leave the federal agents free to presume whatever they like and whatever profits them. You have a choice. You can deal in Federal Reserve notes, IOUs, or you can deal in lawful money, United States notes. You can use the bank as a gratuitous bailee, or the bank can use you as a subject bailer. As American state nationals and American state citizens, we should not be using federal notes, but as our identity was stolen while we were still babies in our cradles and we were never told otherwise, we were never given disclosure, afforded our exemptions, or told about this choice. When we endorse anything, that is, sign a banking instrument, we need to use a byline, reserve our rights, and declare our intent by writing redeemed 12 U.S.C. 411 in lawful money. This backs up our instruction to the local bank CEO regarding our accounts and assures that our instruction regarding each instrument will be followed. Every time we do this, we reduce the so-called U.S. national debt by the amount being transferred. Since the perpetrator's intention was to create an insurmountable, eternal, national debt, nobody was ever told how to discharge it via proper signature, and thus we didn't sign the bank instruments in this way, and the debt simply grew and grew and grew, ad infinitum. So we need to use the magic words and say, there has been a mistake, and we need to transfer our accounts, and we need to instruct any federal banks or credit unions we have to work with, and we need to properly endorse all bank instruments from now on. A small red ink stamp set up with the by line like this, by blank, with space for your signature, a small C with a circle around it providing copyright notice immediately following, and the disclaimers, all rights reserved, and redeemed 12 U.S.C. 411, in lawful money underneath. You might also add your account number, but if you are going to change banks, maybe not. This will make properly endorsing checks and other bank instruments far less tedious, and make sure you get the verbiage right every time from now on.